All right, now we have a set of practice questions specifically geared towards the judicial branch of our federal government. All right, number one. Key decisions of the Supreme Court under the leadership of John Marshall solidified the power of the Supreme Court to do what? Okay, John Marshall was the Chief Justice of the Supreme Court, and he really set a lot of standards, set a lot of precedents here. Okay, so could it be A, try cases between states? Okay. B, accept appeals from lower courts to federal courts. C, try cases involving foreign diplomats. Or D, review the constitutionality of a state or federal law. John Marshall is most closely associated with this whole concept of judicial. On the number two, the judicial branch of the government is responsible for making laws, suggesting laws, interpreting laws, or carrying out laws. All right. Making laws, that's our legislative branch. Suggesting laws, that really doesn't fit, so we can remove A and B. C, interpreting laws, that would be our judicial branch. And carrying out laws is done by our executive branch. So this one's going to be C. All right, the ability of Congress, I'm sorry, the ability of the Supreme Court to declare an act of Congress or of the President unconstitutional is an example of capitalism, states' rights, federalism, or judicial review. Now, capitalism is an economic model. Okay, so capitalism has nothing to do with it. We can remove A. B, states' rights. The Supreme Court doesn't really have much to do with states' rights, so we can go ahead and remove that one. C, federalism. That's kind of spreading power out amongst state governments. Well, in this case, we're talking about the Supreme Court, so this is part of the federal government. So no, that doesn't make sense. And then D, the judicial review. That's what we already talked about. We talked about it with John Marshall. The answer is D for this one. Number four, the use of the newspaper headline below, or sorry, use the newspaper headline below to answer the following question. United States Supreme Court rules Colorado's search and seizure law unconstitutional. In other words, the Supreme Court said that something is unconstitutional. Okay. Um, this newspaper headline relates to the principle of what? Now, what principle this is? Well, obviously, we've just talked about it a couple times. Judicial review. In other words, they saw that the law, that Colorado state law was against the U.S. Constitution. Therefore, all right. Number five, how can a judge ensure the right of a person to a fair trial? All right. A, by selecting the first jurors who arrive at court. This is very, very arbitrary and has nothing to do with fairness. So let's get rid of A. B, selecting jurors who are not biased about the case. Okay, well, that should lead to fairness, so let's hold on to B. C, by selecting jurors who already have information about the case. Um, Technically, a juror is only supposed to get information from the court proceedings, not from anywhere else. So this could create a definitely an unfair advantage for one side or the other. So let's remove C. D, by selecting jurors who have enough time to hear the case. Well, that makes sense, but by law, if you all the jurors, whether they have time or not, will be required to listen to the case. So it's going to be B. All right, number six, the table below describes the federal government. Okay, we have our three branches: executive, legislative, judicial, and over here it has the member, the president, the Congress. So which of the following belongs in the box? All right, the head of our judicial branch is our Supreme Court. That would be C. All right, the Supreme Court case of Marbury versus Madison established which constitutional principles: that due process, judicial review, implied powers, or equal protection under the law. And this one, I believe, is actually going to be judicial review again, B. Number eight. In which of these cases did the U.S. Supreme Court interpret the necessary and proper clause of the U.S. Constitution? Well, we just said Marbury versus Madison was executive review, so we can go ahead and get rid of that one. Tinker versus Des Moines School District, that had to do with school dress code and protest and freedom of speech amongst students. D, Brown versus the Board of Education, that was had to do with the integration of public schools. So this is going to be B, McCulloch versus Maryland. Okay, that necessary and proper clause is also referred to as the elastic clause. In other words, Congress will have the powers to make any laws necessary for that particular situation. Right? A grand jury decides, well, basically who's going to be indicted. Okay, this one's very simple and straightforward. So that's what a grand jury does. C. Which of these excerpts from the U.S. Constitution gives the Supreme Court the authority to review a law passed by Congress? All right, so let's look at the A. The judges shall hold their offices during good behavior. That has nothing to do with it. We can remove A. B. He, the president, shall nominate judges of the Supreme Court. This basically talks about rules for the president, not the judges of the Supreme Court. So we'll go ahead and remove B also. C. The judicial power shall extend to all cases arising under this Constitution. All right, number 11. In 1816, the federal government established a national bank. The state of Maryland imposed a tax on the bank, but the federal government refused to pay it. So, in this case, Maryland was trying to tax the federal government. That's pretty funny if you ask me, but whatever. On what basis did the U.S. Supreme Court rule in favor of the federal government? A. Government is limited by the consent of the people. Well, it's a nice little statement, but it really has nothing to do with this, so let's remove A. B. Neither the federal nor the state government should be involved in banking. Well, they didn't rule that. That's not what happened, so we'll remove B. C. While the majority opinion prevails, minority rights should be protected. This doesn't say anything about minority or the majority, so let's remove C, which by default makes D the answer, but let's look at D. When federal and state powers conflict, the federal government is supreme. In other words, states can make any law that they want, but if the federal government makes a law that doesn't coincide or doesn't, go with that law, the state law bows to the federal law. The state law is inferior. The federal law is the supreme law of the land. 12. Some students were accused of violating school policy by leaving school grounds while school was in session. Before being suspended, the students were given an opportunity to explain their reasons for leaving school grounds. Which of these principles of law applies to this situation? Okay, well, let's go through and figure this out. Due process means that you had a policy in place for dealing with certain things, and you went through that process. B, majority rule. That's basically you take a vote, and however the majority believes, that's what happens. Okay, this has nothing to do with that. C, checks and balances. In other words, each group has power over each other. Okay, again, doesn't have anything to do with that. Separation of powers. In other words, you don't give supreme power to one entity. Again, it has to do with our Constitution, but not this particular principle. This right here is due process. If you suspend the kids and don't give them an explanation to explain themselves, you've violated their due process. Maybe there was an emergency. Maybe something happened. Maybe nothing happened. Maybe they were skipping school and breaking the rules. Either way, you have to go through due process to make sure that their rights were not violated. All right, which types of these cases would be tried in a civil case? Now, we have civil versus criminal. Kidnapping, lawsuit, shoplifting, or traffic violation. If you break a law and it's something that a police officer is going to fine you for or arrest you for, that becomes a criminal issue versus a lawsuit, suing somebody to get money that they owe you or suing somebody because they've caused damage. Okay, that is a civil case. That would be a lawsuit B. 14. Which of these is part of the judicial branch of the U.S. federal government? Okay, again, this is just repetition of what we've already stated. It would be the Supreme Court. And number 15. A person using another person a person suing another person in a civil case is called the plaintiff. The plaintiff is a person who brings a lawsuit against somebody else.